the legalities of running a business is the things we avoid until it's too late. So, what's sort of a general overview to start us on what we should think about from the legal side of running a business?
Uh, yeah. Uh, Sorry about that. Um, Good question, important question, heavy question. I think that most people uh, go and speak to their accountants and their banks, and they say, "I've got the money. I've got some tax advice. That's all I need, or some bookkeeping advice. That's all I need. I've got premises. I've got one or two business contacts or 10 business contacts. I have a couple of people who are willing to support me, and that's all I need to get started up." Now, that is the novice approach, and most people do that. And I'm not at all critical of that because that's just the lay approach, right? I think what's really important is that once people start realizing when you get into business, you're entering into a world of, of obligations. You have to think about it transactionally. This is not, you know, asking friends for money for a cheeseburger, right? So you are actually going to be borrowing money from a financial institution. That financial institution isn't going to give you that money gratis. Okay, they will want you to sign forms. They will want you to make undertakings and give assurances that certain things will be in place. When you complete an IRD form, the IRD form asks the IRD asks you to complete a declaration. So this is really, really serious. Whatever you say impacts uh, not only your livelihood, but potentially the expectations of others. And so, my initial advice to anybody is that do not treat this in a nonchalant, casual way. This has to be a serious undertaking. And the internet is 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 just rife with all kinds of examples of somebody who says, I got $5,000 and in 30 days I made 50 grand, and all kinds, and people who are giving advice on sales tips and on Amazon and eBay, resellers on eBay, and all kinds of things. Well, you can't just simply pick that up and make money overnight. That doesn't mean some people uh, don't achieve that. But just because something works 9 times doesn't mean it won't break down on the 10th time. And that's what you have to allow for. You have to allow for, if things go wrong, will I be protected? If things go wrong, will the people who rely on me, will they lose out? Because if they lose out, things will turn sour very, very fast. Your friends will become people who hunt you down because they're chasing an unpaid debt. Or you promise to deliver something and it's never been done. Now, in our small landscape here in New Zealand, we find that builders and plumbers and mechanics and electricians often fall into this trap, right? Um, and that's because they have thought about skill, i.e., can I do this? But they've not thought about obligations. And when you think about obligations, your mind turns, doesn't it? It's now something serious. It's something that me and my friends never talk about, but I remember my dad and granddad talking about it, and I remember reading that word in textbooks. I didn't think it applies to me, but it does. So you have to think transactionally. If things go wrong, is it a mess that I can clean up? Yes. How long will it take? What will be the cost of cleaning that up? How much damage will I do? Am I prepared for that disappointment? And a lot of young entrepreneurs are not. I spoke to somebody and he had read about 6 or 7 get rich books, self help books. He was an expert in the Tony Robbins sort of speak on how to make money, what to do, how to do things quickly, and how you're going to obtain capital and make these investments and get rich very, very quickly. You'll flip properties and do all kinds of things. It never occurred to him that in taking all of those things on his shoulders, he was taking on something. It's a small word. It's a simple word. RISK, risk. It never occurred to him because people don't talk about that. And when I talk about obligations, I'm talking about risk. So entrepreneurs need to know about their obligations. So, in layman's terms, what are your duties? And when I talk about duties, I really mean legal duties. So, for example, you get a loan from the bank. What are your duties to the bank? Well, the first thing is you've got to use the money for the reason that you had told the bank you were going to use it. I suddenly got $100,000 from the bank. Right. Look at the terms of the offer. The bank makes it very clear that, dear Mr. X, we're giving you $100,000 and we expect you to use it for 1, 2, 3 reasons. And in 3 months, we expect to see 1, 2, 3 things from you. Right? When you sign up for a new IRD number with the IRD, you will also have to make a GST application. If you're going to be running a business, they will ask you, do you expect your income to be over 60,000 or below 60,000? How are you going, do you have employees? Yes or no? Well, how are you going to deal with PAYE and employee obligations, tax obligations, that is? Those sort of things. So this is serious business. And you have to take it very, very seriously. Those obligations, your legal duties, have to be at the forefront of your mind at all times. And some people feel that's far too burdensome. They'd rather go to a get rich quick seminar because those seminars make you feel good. You leave on an emotional high. And conversely, when you speak to people like me, you feel quite deflated. So I have the opposite effect. But the point is that we live in a real world. We don't live in a make believe internet world. In the real world, there are obligations, there are duties that and your word, if you give your word, you have to stand by it. If you've promised to deliver a product or a service, you need to deliver it. And once you deliver it, then there is a financial consequence to that. Most people think only about revenue and then later profit, but tax obligations as well, your obligations to your creditors, and those sorts of things. So in a nutshell, those are the things to think about. And then there's another part of all of this, which is when you're dealing with obligations, you have to work out if you're setting up a business, then what structure or legal structure you're going to have. And that's very important. Do you want me to elaborate a little bit on that?
Yeah, you got an interesting insight on how protected or unprotected a business owner actually is with those structures. So yeah, what are the structure options and where do they go wrong and how are people doing them wrong, you know?
Yeah, sure. So the most common structure is, of course, a sole, what we call a sole trade, and what that really means is, one man, his ute, and his dog, and a few tools, and have decided to start up a business. And he prints a card and he says, "My name is Jack Smith, and I do house repairs. Call me." He can register for GST in his personal name. He's personally liable for everything. And in the old days, that's what a lot of business people did. And the reality is that a lot of them stood by their word, and that's when the idea of my word is bond comes about. Because if anything happens, everybody knows Jack Smith. They will hunt him down. They will spread, terrible stories about him, and he won't be able to show his face in the local pub anymore because he's done a shoddy job. He hasn't performed, and he's left unpaid debts. So, that's the sole trader. The most commonly used business vehicle in the country is the company, or the limited liability company. And most entrepreneurs set up a company very, very quickly. New Zealand's one of the easiest places in the world to establish a country, to establish a company. Sorry, there's quite a lot of background noise over here because of the traffic on the road. Um, but it doesn't take a day to establish a company in New Zealand. You can do that online. Your accountants can do it. It's reasonably cheap, and you can do it efficiently. But most people, when they set up a company, they will often see an accountant or bookkeeper, and in half a day the company's set up. There's been no discussions about uh, who are going to be the directors of the company, what are the duties of the directors, is the person qualified to be a director or not, who are going to be the shareholders of the company. Jack Smith might go to his local bookkeeper and say, and I would like to set up a company. My wife and I will be the directors, and both of us will be shareholders, and we'll set it up for 100 shares. And we'll open a bank account with $100 in it. And the bookkeeper says, sign here, sign there, and you're done. And then Jack Smith takes on, various contracts. So the question, of course, is, should you be a director or not? And should you accept shareholding in a company or not? And these are important questions. You cannot approach this in a casual way. You can't simply say, well, my cousin did this a year ago down in Invercargill, and this is how they did it, so we'll do the same. I, you know, when again, if you take it seriously and you realize that now we're moving out from an idea and stepping into fruition, to making that idea reach fruition, then you're going to have to take it very seriously. Well, that would be my advice anyway. Think about who the director of the company should be. Why is that important? Because the director is in charge of managing and directing the company, hence the term director. Right? You are leading this ship. The shareholders are not directing, but they are putting in money, or at least they ought to be putting in money. And so they have what is called an equity stake. They have they have a serious interest in how the company does. And so it's really important to work out who's going to be part of this structure. Getting hold of a neighbor's son because he mows your lawn really well every Sunday, and say, well, he's over 18, he's not had any criminal convictions, and he's available, and I trust him, I know where he lives, and he can be a director with me. That's a really bad idea. It's unfair on him, and it's unfair on you and your shareholders, because this individual might be very good and very trustworthy and know how to mow lawns, but may have no idea about the business that you're really entering into. And someone who has a passing knowledge of business doesn't necessarily mean that they have the skills, the requisite skills or qualifications to actually run it. So it's really important about who you have as directors of your company. and also who the shareholders should be as well. Excuse me.
No, you're right. I'd be curious on the consequences of those decisions because, like, I get, okay, the director's the person that's directing the business, the shareholder's got a vested interest financially. So, what is the consequence of picking a bad director or a bad shareholder or structuring it a certain way, just so that that incentivizes the motivation to do it right? So, what's the consequences of these decisions?
Yeah, so I hear this from accountants, I hear this from experienced property investors or clients. I used to hear it a lot more when I was a younger practitioner, um, working in bigger practices. And most people would say, it's okay because I've got limited liability. And accountants would often say, oh, it's limited liability. And I would have people who said, look, we've invested in 4 ventures recently. And when you talk about exposure of risk, don't worry, I've got limited liability. Well, here's the funny thing. That's a myth. The limitation of liability is a myth. Um, it's never been true. A company has limited liability only in certain circumstances. And directors, if they breach their duties under the Companies Act, and I'm primarily referring to, I believe it's sections 131 to 137 of the Companies Act. If they've breached those duties or any one of those duties, then immediately, the director is liable, is personally liable. So this notion of a director having limited liability and allowing the company to take on obligations and take on contracts and all, and it's okay because even if we can't do it, I won't be sued or they cannot sue me personally, is actually is a dangerous misconception. It leads to all kinds of worrying behaviors and patterns of behaviors and difficulties. Uh, if a company, if a director of a company has allowed the company to trade while insolvent, then the director has breached, I believe it's section 135 of the Companies Act, which talks about a director must never allow a company to trade when it is in a financially vulnerable position. The director will be liable of allowing the company to trade recklessly. So it is, a company director would be not only liable under that act, under that section rather, but probably in relation to a duty of care as well to the company. So directors have to be very mindful of the documents they sign, the contracts they negotiate, and the arrangements they get into. Because if they, for example, have decided that they've had a really good uh, half year financially, but they haven't paid their GST, then they decide to take on, and just say, hypothetically, the GST obligations owed to the IRD around $300,000 to $400,000. Then they decide that they need new machinery, or they need, new IT equipment or something like that. They go to the bank and they decide that they're going to borrow money. Borrow, say, $300,000 or $400,000, and one of the questions the bank asks is, are you solvent? Well, they could answer technically, yes, we are. Have you met all your obligations? Um, and they could answer that question by saying, yes, but uh, yes, we have met our obligations and will continue to meet those obligations. But if the IRD debt is not paid, then they're technically insolvent because the amount of the debt is much greater than the income they've received and the amount in their bank accounts. And if the IRD stopped and by their offices the next day and said, well, you owe us about $400,000 and now you have to pay us that money, if they're unable to pay that money, then they're in trouble. And more importantly, they've misled, they third parties that they're in business with, banks and other people who are reliant on them for services.
Interesting. So it sort of makes
So,
sense. So it's kind of like the directors and the Companies Act have these certain obligations and duties, and their limited liability gives them some protection if they meet that level of obligation. But if they breach that, then the limited liability doesn't actually exist, or is it just never existed at all for them? You know what I
no,
mean?
no, the corporate veil, which is the corporate protection of the limitation, will be pierced. It just means that they no longer enjoy the protection of the law. They no longer enjoy the protection of that veil, this shield, which is their liabilities are limited. But there are other obligations such as acting for a proper purpose. I've already mentioned duty of care. Um, the company not being allowed to take on obligations when knowingly it cannot fulfill those obligations. It was reported in the press a little while ago about the main Zeal case, where three directors, including a former prime minister of this country, were implicated, and proceedings were issued against them. Well, in the main Zeal case, they the company went into receivership, then was liquidated for $110 million owed to unsecured creditors. What they found is that the company, then the directors, were sued personally by the liquidators. And what they found was, in fact, the company had been trading for a few years when it was in a financially precarious position. It was vulnerable, but yet it was taking on these major contracts to build and construct um, structures around Auckland. It entered into various arrangements with the IRD and so forth, but and with third parties, with subcontractors and various other parties. So, so in that case, how is it if limitation of liability is an impenetrable idea, i.e., it stays at its course no matter what. It's never compromised. Then how is it that those three directors got sued? And those three directors got sued for reckless trading. Um, you know, so exactly what I've been talking about. But managing a company, in fact, is what the word director means. You're directing the affairs of the company. You're just not a director. You cannot be a director only in name. I used to have, when I worked uh, in the commercial area and I worked for a tax partner, sometimes I'd be asked to set up companies, and occasionally someone would say, "Don't worry, I'm only a passive director, or we're going to be setting up this venture, and I'm simply a passive director." Even as a young lawyer, I always thought that was very, very curious, because how can you passively direct something? But of course, I think the fault was with me. looking at things a bit too literally, whereas more experienced accountants and said, "Oh, don't worry, little grasshopper. We've done this several times, and we've always done it this way." Now, it always perplexed me. Well, we have good case law that proves, individuals like that wrong. A director cannot be lackadaisical. A director cannot be um, un, uh, uninvolved. There was a very famous uh, case a few years ago. A doctor up up north, he patients of his had a son who was interested in foreign currency dealings. So the director is then convinced, after meeting the son, grown son, to invest in the business with him. And he does that, and he puts in a small amount of money initially to get the business started, right? But the director, the doctor is a director of the company, together with this other fellow. This other guy, he's managing the business every day, and he's acquiring funds from investors. Now, after a little while, things start going wrong, and it's discovered that this other fellow has been embezzling the funds. He's been taking investors' money and using it for his own purposes. Now, when the doctor finds this out, he reports the matter and he tries as best as he can to sort of clean up the mess, but it's too late by this stage. The liquidators come in and they find that a lot of money is owed to investors because a lot of people trusted. Here's a doctor, he's a director of this company, here's this fellow, he's an upstanding member of the community. Yes, of course we're going to invest $100,000 because the returns are so great. This fellow, this guy's not pursued by the liquidators simply because I can't remember, this is a few years ago now, either they can't track him or they realize he's actually he's financially insolvent. He's financially in a pretty bad state. He's insolvent himself. They go after the doctor because the deep pockets principle applies, right? The doctor is independently wealthy. He has deep pockets. The doctor's arguments are essentially this: that look, I didn't run the business. I was a director and I invested my own money, but I trusted this other fellow. And he ran the business, and occasionally we talked about how it's going. So this is patently unfair. I mean, this is grave injustice that I'm now being pursued. I didn't do this. Why should I be pursued? And the courts actually, while being sympathetic, they disagreed. And they disagreed because they found that the doctor was busy in his own practice. He gave no financial oversight or governance oversight to the business. He did not have regular meetings with his business partner, the other director. He didn't go over the financial affairs, the business, the balance sheets, and so forth. He didn't ask penetrating questions, and he didn't demand answers. In other words, I think the courts said that he approached his formal duties with a degree of informality, right? Because he was operating on trust and confidence. He knew the boys, this man's family, and they'd become acquainted and all of that. So he was liable, and he had to settle the debt personally.
Yes, well, just to go back, so that sort of explains to the director, like it's not an easy decision, and there's like consequences for the person that mows the lawn, and there's consequences for you because it could lead to the piercing of the Companies Act and your limited liability. Maybe they do something bad. What about the shareholding side of things? What's the consequence of structuring that incorrectly or a shareholder?
Yeah, I think shareholders, when businesses go bad, in other words, when directors are derelict in their duties, shareholders often have to meet the cost of that, um, and they lose. Um, when you're starting a business, a new startup, the shareholder is not going to make money in the first 3 months, 6 months, maybe in the first year. I know of shareholders who have not made money in the first 3 years. They've put money down, they're not earning interest on it, they're not getting paid dividends. And the business is just there. They're hoping for the windfall. They're hoping for, that second anniversary or third anniversary when the business actually gets a big contract, where everyone can be paid out. And the problem with shareholders is that they often have to rely on the word of the directors. The directors have to tell them how things are going, and they rely, obviously. If you're an interested shareholder and this means something to you, you will be you will want to speak to the accountant of the business as well, and it would be good if you had access to the company's lawyer as well. Shareholders should always check the tax obligations of the company. That's very, very important. In one case that actually went to the Court of Appeal, it was a mom and dad type of operation. There were about 5 or 6 people who knew each other. They were independently wealthy. They invested in a printing business. They appointed somebody to manage the business. This person committed various acts of fraud, and the company became insolvent. These individuals were shareholders as well as directors. And the courts found that they were liable, so they actually lost their investments. And they had to meet all the obligations, in this case, owing to creditors and the IRD. So why was that? Well, if a shareholder, for example, is aware that, and in this case it was quite a lot of money was owed to the IRD, but the shareholders in this particular case, they knew that there was an IRD debt that couldn't be paid by the business. That's not a good time to continue to put money in the business. And if a shareholder is aware that there is a debt owing, and I don't mean due dates. For example, you know, if you know that in 60 days you have to make a payment to the IRD, well, you're not in breach of that. That time hasn't come yet. You just have to make sure that the business and the directors are making sufficient arrangements to meet that obligation. And if they cannot, then they need to tell you now, not 3 days before it's due. The problems arise, of course, when you've passed the due date and now you're 30 days into, that red period where the debt is clearly outstanding. Shareholders must always keep an eye on tax obligations. Tax obligations are usually a good sign of where the company is at financially. Now, the tax obligations could be GST, they could be PAYE, right? So if your employees are not being paid in a timely way, then that's a problem. If your employees have been paid but their PAYE has not been paid, that is a massive red flag, right? And if your PAYE hasn't been paid and you're behind in GST, then this is the biggest flag you've ever seen right before your eyes. And if you stay silent and do nothing, then that's problematic behavior. And shareholders must be aware of those things. It's critically important.
what do you do once you're aware? Like, do you like rush to tell them, please buy this off me, or just
Oh, look. No, you won't be able to sell because you'll be in breach of warranties and that kind of thing. But you've got to make urgent arrangements. You've got to make urgent arrangements, and you've got to press the directors of the company to call an urgent meeting with the IRD where some kind of negotiated plan can be made, perhaps a payment plan or something like that. But you've got to have an urgent meeting with the finance people, the legal people, and the directors of the company and other stakeholders as well. You know, that old adage, sweeping it under the rug, never solves a problem. All you end up is with a massive hump on the floor, and you don't quite know what's there, and you're afraid to look, you see. So you've got to deal with problems directly. And this ties in with how we started this conversation about obligations, about the fact that this is serious stuff. This isn't a 30-second clip on YouTube about how to get rich. This is the real world. So, these things are important. They matter. The one thing I would urge every entrepreneur, now whether you're starting off or you've been doing this for 10 years, is get good advice. Surround yourself with the warm embrace of good advice. And that has to be good financial advice, yeah? But it must be good legal advice as well. So some companies don't see their lawyers until they have to sign a lease or they're entering into a contract that their accountants cannot explain to them. Most companies keep their accountants close and their lawyers at a distance. And the reason for that is, most people think lawyers are too expensive, or I've got this all sorted out. Me and the other guy, we met at a bar. We wrote the contract on this serviette, and this serviette represents our contract. If we show this to a lawyer, he will overly complicate it. So we don't want a lawyer involved. We will do this ourselves. We've got our accountant, and we can make this work, right? So it's the fear of the unrealistic fear of complication, and secondly, the cost that tends to drive some young entrepreneurs or small businesses away from getting good legal advice. And sometimes, and I've recently come across this, where they simply go to their local conveyancing lawyer to get advice, and the conveyancing lawyer will have a legal exec assist them on something, and they think, gosh, it's all done. I've met that requirement. I've ticked those boxes. Yes, a legal expert's cast their eye over it, so it's all done. For shareholders, I think having a shareholder, if the venture becomes successful and people are beginning to be well paid, the directors and stuff, if we're talking about that kind of venture, it's imperative that there has to be a shareholders agreement. I would encourage even startups to have a shareholders agreement, and in fact, I've done that for a number of startup businesses. Having a shareholders agreement is imperative.
what does that
Um,
look like, and what should you think about with that? Because
well,
I was involved in insurance, like shareholder protection, we come across a lot because I work with advisors to insurance, and the buy-sell agreement's an important piece as well. So, what should you think about with shareholder protection? I mean, shareholder agreement.
yeah, so a company constitution deals with the rules of the company and how it operates and what to do in certain situations. A shareholders agreement applies those same principles to the arrangements between shareholders. So, how much does each shareholder put in? What rights do they have? You know, what about the ability to call a meeting? When do they get paid? What are their expectations? What about a dispute between shareholders? That's often common. then? How do you resolve a dispute between shareholders? What about buyouts? Can a shareholder obtain more shares either from the company or from other shareholders? And if so, then what is that process? How does that look? Um, and also, how does a shareholder exit the company? How do they get out? Um, can they sell their shares? And if so, for what price? Is it market rates? Is it based on an independent assessment? Um, is it based on market rates plus something else? Um, those sorts of things. I think that's very, very important. I've seen a number of businesses where um, at the stage of setting up, at that initial stage, these men and women were behaving like the closest siblings ever. The men are blood brothers. They're visiting each other's homes. They're holidaying together with family and all of that. And that by the third year, they don't want to be in the same room with each other. They're making good money, but they just can't stand each other. How does that? How do you deal with that? And so the shareholders agreement you know, must have all the elements that address those sort of situations. You cannot have a shareholders agreement that will contemplate every scenario. But by and large, in a general sense, we must be able to, at least when we look at it, we must be able to get some guidance, clear guidance, and some clear rules on how to either solve a problem or to deal with something that is either unpleasant or urgent or time critical, and that is beyond the directorship of the company. And the other thing is that if a company grows, then you're looking at developing the company. That often means expansion. That often means taking on more people, taking on new contracts, taking on new obligations. And that also means sometimes you have to go back to shareholders and say, more money, please. Right. The right of the shareholder to get back their money is very important. And shareholders agreement must address that.
And on
I,
the
I was
structure thing, oh, you carry on. You're on the floor.
no, I was involved in one very unpleasant matter. The client was using other people, but then came to us to resolve this. We found that they had invested in a business, uh, and it was in the hospitality area, and he was a director with somebody as well as the shareholder, and he had operated on a huge amount of trust and goodwill, and it was only later, after he had been in the business for about a year, that he realized that the other shareholder had not put in all the money that they said that they did. He realized, unfortunately, and quite alarmingly for him, that he was in fact the main provider of capital for the business. What's even more unfortunate was that the other business um, player in this, his business partner, a fellow director, actually managed the company. He was quite a strong personality and tended to not only speak loudly but dominate every meeting they had. He ran the company, and he managed to convince my client that he knew vastly more than my client. And in fact, he had connections all over the place. And he was able to do all these deals. And he, in fact, had connections with a major political party as well. The irony is, of course, he decided that he would build his profile by making a donation to that political party. But he got my client to sign the check and use his own money. And they did so on the basis that this would improve the profile of the business. But it ended very, very badly because the other guy had not invested much in the company, but ended up taking the bulk of the capital out, and proceedings were filed and that kind of thing. So having a shareholder is important, but you've got to know who you're doing business with. And sometimes your closest friends can turn out to be the people that you end up being hurt by the most. So I think that old adage, know who you're getting into bed with, is very important. A shareholders agreement helps in dealing with things if they turn sour.
And just to sort of wrap things up, so we started with the structure. You got the director, you got the shareholder, should have a shareholder agreement. You should be conscious that, you can still be liable if you don't follow the Companies Act. What should you, in terms of setting it up correctly? What's best practice and what are the options?
I think you've got to, obviously you'll enter into business if you have the skill set required to operate that business. That's a given. You don't get into the wine business if you've decided that you've taken a vow to abstain from alcohol all your life. That's madness. So you've got to know the business. So you've got to have that. Those are the requisite skill sets. You've got to know the business. You've got to know something about how to operate the business, and you've got to have at least a few contacts around. Then you've got to work out who are the people that I can trust and who will support me, and more importantly, who will hold me accountable. So if things go wrong, then they will ask me the hard questions. Do not surround yourself with yes men. That's a bad idea. I strongly advise against it. You need people who will hold you to account, because if they really care about you, they're really interested in your well being, professionally and personally, they will hold you to account. They will. It's about integrity, isn't it? And it's about good ethics. Um, and you want people who can support you and you can rely on, but they should be able to rely on you as well. And if you're doing something not kosher, then you should expect these people to tap you on the shoulder and politely ask you to explain. Then you need people around you who will also, in a professional sense, help you to correct behavior. So you need the professional advisors. Now, if you've got these things, you're more likely to attract good capital. You're more likely to attract people who are willing to lend you money. If you can show that you've got a good company set up, you've got a constitution, you've got good legal advisor, you've got a good accountant, and you've got a good business plan of some kind, and an accountant will help you with those things, then a lender will more often than not be interested in having conversations with you, right? But if you've got something written on a serviette, and then the guy who mows your lawns has agreed to be a director, then it doesn't give a lot of confidence. There's no sense of reliability or commercial reliability over there. So that becomes slightly problematic. So, you know, look, it's all case by case, really, and we customize advice to people. But the main thing is, um, I personally encourage people to think um, transactionally, to think about entrepreneurship, to think about investments. I like it when my clients do well. Obviously, I don't get to bite that fruit. When they're doing well, they pay me nothing. They owe me nothing. It's just nice to know that people we've worked with are successful and are doing well, and they're doing it properly. They're thriving. That gives one a sense of tremendous fulfillment. and now I'm speaking as a professional advisor about how I feel about these things. Um, but if you arm yourself with knowledge, knowledge never hurt anybody. And arming yourself with the right knowledge is really very, very important. Um, so I think surround yourself with good advisors. Do not find yes men or women. Do not make big decisions based on a whim or based on what Harold two doors down told me. Carry out due diligence, be thorough, be meaningful, and be purposeful. Because once you set up a business and you put the signboard out, people have expectations. You have obligations. You have duties to fulfill. You cannot treat this like, the family birthday party where you promise to sing and then you at the last minute decided that your singing skills weren't good and you weren't going to embarrass yourself. No, once you've said something, you have to deliver. Um, and people talk about having good systems and good IT systems and good this and that and having good insurance and all those things. I agree with all of those things. But respectfully, those things come later down in the list. If you've got this house, then how you furnish it is important, but you need the house first, right? And that house must withstand scrutiny. It should be able to withstand, a few tremors and, you know, strong gales and that kind of thing. So those are my thoughts, and of course I'm having this conversation with you, in a sort of a matter of fact way, just to give you an idea of my thoughts on the matter. But in reality, if clients were to come and sit with us, then we would be having conversations in extension of this. There would be more formality and would be perhaps a bit more serious
Cool, mate.
about
Well,
it. But yeah, yeah. But look, hopefully this kind of makes sense. I could talk about these matters for hours, but I'll be boring people to death, I suspect.
no, you did well. It's an important thing, and I think I've heard of it acknowledged that they are liable and there are
Yeah.
consequences for not meeting your duties. So, on that note, thank you for coming on, my friend.